SEAC rules. We know from the SEAC rules that at the point at footnote 6, it mentions, of course, that if parties were going to, if the SEAC rules do apply, of course, China did have an influence in that. But that is not the problem in this instance. The problem is that we've chosen and used, of course, the SEAC rules to choose the CISG. And that is the crucial, important part of this, because one of the parties in this instance, namely our client, has its place of business in Mediterranean. And, of course, with the formula that I've just presented to the tribunal, that means that the writing requirement through Article 96 applies. Now, of course, at the next step, which respondent has suggested, there is somehow perhaps an issue with how we look at Article 12 and whether or not it creates a positive writing requirement. But when we look again at Article 12, and we don't, in fact, cloud it with any ambiguity, and we read it for what it is, we see quite clearly that, again, Article 12 is quite clear on this. It states in its own writing at line 3 of Article 12 that it uses the words "to be made in any other form other than in writing" does not apply. And that is of course, in reference to Article 11 and 29.
Councillor, your opposing counsel picked up on the point that we raised, that there is a flexibility in arbitration that is perhaps absent in a state court. How do you respond to that?
That is true. This is an arbitral tribunal, and of course, there is no doubt it has more flexibility than a state court. But as presiding arbitrator has already mentioned, he brought up the issue of enforceability and the need for the arbitral tribunal, of course, in conjunction with Article 7 of the CISG, that is the uniformity provisions, to make sure that whatever award is created in these proceedings is at least enforceable for either party. And that goes to what presiding arbitrator and the panel talked about in regards to public policy, which is a very crucial part, of course, in making any award. Because if the tribunal in some way derogates from Article 12 and then, say, for example, an award needs to be enforced in Mediterranean, there will be huge problems for the tribunal, even though it has that flexibility for enforcing that award, and that will create also problems for both parties in this case.
To what extent?
Sorry, counsel.
Yes.
On balance, you said, of course, Article 12 said party cannot derogate. On the other hand, the party did derogate. So on balance, what does the tribunal need to do between this conflict of party autonomy and the substantive law side, whether we should be more careful for the party autonomy or on the substantive law side?
With respect, Mr. Arbitrator, the two don't need to be exclusive, and that is our submission. The two principles in this case are interchangeable. Party autonomy goes very well with the CISG, and by picking it, the parties have not derogated from it. That is the essence of picking the CISG and why the parties would pick it in the first place. Because, as respondent has suggested, party autonomy comes with decisions. And by picking to choose to do business with a country which has its place of business with an Article 96 reservation, it has used its party autonomy and its decisive power to enforce the CISG and thus have the writing requirement apply. So, if there aren't any other further questions, I'll continue.
I was just going to ask, you raised the question of enforceability. And just to take it outside of the specific context, how important should the question of enforceability be in terms of an arbitration panel making a decision?
It should be.
And let me just finish. And should we look practically as to where enforcement will actually take place? I mean, all of the assets, I gather, really are in Equatoriano. So why should we care whether it's enforceable in Mediterranean?
Well, certainly the assets are in Equatoriana, but at the same time, our side, if perhaps we had to enforce in some way the accountability of that particular award back in our home state and have it recognized, for whatever reason, of course, the enforceability of Equatoriana, we agree with Madam Arbitrator, has a lot of weight, but that does not necessarily mean that there won't be other issues which will need to be particularly for respondent back home, that need to be enforced.
Councillor, can I take you forward in respect of public policy
Yes, Mr. Arbitrator.
and the enforceability provisions in your convention? I can imagine easily that public policy in that context would stretch to big picture issues, something in French it would be called ordre public, something that is sufficiently major to go to the root of the arbitration. Is the matter of whether or not a document needs to be in writing, is that really of that importance?
Mr. Arbitrator, we would submit that it is, because the fact that that Mediterraneo has made that Article 96 reservation, and the Supreme Court, of course, at Statement of Claim, paragraph 32, I'll find the page for the tribunal, states that...
Counsel, you can take it. We're familiar with the record. Don't feel obliged.
Thank you, Mr. Arbitrator. I was going to give you the page. But we know that the courts have interpreted Mediterraneo's Article 690 declaration to mean that a writing requirement applies. And that goes to the question of courts. Because we have a situation where courts have made a decision that, of course, in terms of public policy, needs to be respected. And that is a significant factor with regard to what you said with the writing requirement, Mr. Arbitrator.
Counsel, what you are saying is that if there are any case law in the past, it will be part of the public policy?
Pardon me, Mr. Arbitrator, could you repeat your question?
If there are some case law in the past by Supreme Court, we should take this as a public policy restrictions on this tribunal?
No, Mr. Arbitrator. I'm not suggesting that case law should be used as a source of public policy. I'm suggesting it should be taken into account along with all the other issues of enforceability, as presiding arbitrator suggested to what extent a writing requirement would affect enforceability in Mediterranean.
You know, we don't know for a fact, but let's assume that the situation in the Mediterranean case law, in those cases, there was no selection of the SEAC rules. So there was no adoption of a clause from the SEAC rules. Can that lead us to the conclusion that those cases in Mediterranean really are not relevant to our analysis because the factual setting is different and the SEAC rules add an additional gloss?
Certainly not, Madam Arbitrator, and I'll give you my reason why. Because even if we look at Article 35, it states that the parties may wish to consider, of course, the use of the model clauses, if they wish, but at the same time, the tribunal needs to respect of course, this is stating the obvious, but the tribunal must respect the choice that the parties have made. And in this instance, because the parties have made that choice, rather to select that CISG, that piece of law which works like this, it does not affect, the SEAC rules would not affect in those cases, like you said, because they merely enforce the principle of party autonomy anyway, which works with the CISG, which, if I may, brings me to another point. Article 6 of the CISG seems to support exactly what we are suggesting today. Article 6 restricts, of course, it doesn't restrict the principle of party autonomy, which is reflected in Article 35, but at the very least it suggests and shows that Article 12 is an area where the parties cannot derogate from. And that is because of this dynamic in the CISG. It is a piece of law which is used for international business. We can't have a choice of law which is used for international business, which somehow allows all people and all countries and all businessmen to derogate from the terms of that agreement in some way. Now, excuse my hand movements, but you can see what I'm saying. It simply wouldn't work for the purposes of international business. And it's an important factor to take into account that although the SEAC mentions the issues that you've brought up, the CISG does not derogate from it and merely complements it with the choice of the parties. So, members of the tribunal, to conclude on this issue, we can see that there really is, on this issue, not necessarily a polarized debate. In fact, the debate is somewhat unified because neither party is, even though respondent is suggesting that party autonomy in some way is going to affect the effect of Article 12 and the dynamics of the CISG, we can see that from what I've suggested to the tribunal that there really isn't that much of a disparity between the two concepts. And in fact, the two are meant to work together, particularly through the CISG. And also, It is important that these provisions are respected because for the purposes of facilitating international trade and public policy in individual state courts and jurisdictions, these provisions, of course, must be respected. If that pleases the tribunal, if there are any other questions?
Yeah, let me just take you back to the basics. If we were to conclude that Article 12 actually, because all it says is it does not apply, really creates a gap and leads us
Certainly.
to look to choice of law principles. Could you address that?
Thank you for bringing me back to that point. And of course, this gap issue, which I addressed earlier, is already fixed or addressed by Article 12 when it refers to any other form other than writing. Of course, respondents suggested that creates a negative. In other words, from a negative style provision in Article 96 applied to Article 12, that creates a gap, if you will. But there really isn't any other gap here, because even though that negative somehow affects the negative writing in Article 12, if there is a no writing requirement, it's sort of a double negative, then there is a writing requirement. I mean, because two negatives in essence create a positive. And aside from that, if the tribunal looks at the reference that opposing counsel made to Procedural Order 2, paragraph 33, we see quite clearly there, with reference to what they used to suggest that we should use the private international law and the closest connection test, that provision itself states in clear terms that there must be an absence of an agreement. And in fact, opposing counsel mentioned that in her own words. And I asked the tribunal, is there an absence of agreement here? Certainly there is an agreement, and certainly it is addressed already in the CISG, as I've suggested, and there really is no need to go any further in this issue because of the fact that Article 12 addresses this issue already. And that particular procedural order provision can't be used to state in some way that, oh, we need to refer to the private international laws. That is a second priority, which has already been addressed in this matter.
I guess humorous. Assume that we find that there is a gap that does drive us to a choice of law analysis. What is your response to how we should apply a choice of law analysis here?
Opposing counsel mentioned the fact that the contract, of course, using this provision that the place of the conclusion of the contract somehow affects the fact that the closest connection applies to Equatoriana. But it is, of course, when we look at Article 12 and the actual, we look at who drafted the entire contract, we know that it was, if you give me just 1 second to refer to my opposing counsel. So, pardon me for causing such a strange silence, but we know that when we look at which contracting state in this instance is the closest connection, if you will, to the contract, to this writing requirement, we know it's Mediterranean, and we know that the connection in this instance starts from that state, from that contracting state that has made that reservation. Shouldn't that be the first priority that's taken into account before we look at, of course, other suggestions? And when we look at Article 96, we find at the bottom it states that, pardon me, termination by agreement or any offer, acceptance, or other indication of intention to be made in any other form than in writing does not apply where any party has his place of business in that state. And that point is emphasized there at the end of Article 96 itself. That is where the connection begins. So if the tribunal is satisfied with these answers, I will conclude my submissions if there aren't any questions.
Well, thank you, Councillor.
Thank you,
I'd
Mr.
like to invite Ms. Kiala to engage in rebuttal. And as I said at the outset, we are more interested in what you have to say in this area than what you might wish to say about witness statements. But if time permits, after rebuttal and Sir Rebuttal, we will hear you on the witness statements, but said we're not so interested in that. So over to you.
Okay. I would first like to address what claimant just said regarding the gap, and that there is no gap, or that it has to be filled with a writing requirement. If I may therefore refer the tribunal to Article 4 of the CISG. There it reads that this convention governs only the formation of the contract of sale and the rights and obligations of the seller and the buyer arising from such a contract. In particular, except as otherwise expressly provided in this convention, it is not concerned with the validity of the contract or of any of its provisions or of any usage, and so on. As I said, it states, except as otherwise expressly provided in this convention. It is not expressly provided in this convention that we would have a writing requirement. Therefore, we do have an external gap here. And this external gap leads us again to the party's choice of law clause and the PICC, or if you do not want this, still to the conflict, to the national law of Danubia, the conflict of law rules there, and again to freedom of form.
Before you go there, your opposing counsel referred to the desire for uniformity and consistent application throughout the world, and that that's kind of a guiding principle in the application of the CISG. So isn't it governed, at least inferentially, by the CISG as to how this should go?
Well, actually, what Article 7 says is not only that we have uniformity in the application of the CISG, so an autonomous interpretation of the CISG. Therefore, how claimant would support that we should take into account the Supreme Court decisions of the Mediterranean Supreme Court and then have a uniform interpretation and take them as guidelines does not apply here. It is not wrong that we can take into account national Supreme Court decisions. They can help us to have the uniform interpretation that we need as per Article 7 of the CISG. However, they can only do so if they do not reflect national concepts but go along with what the CISG does want. And since, as I said, the CISG does not impose a writing requirement, but in Article 12 only stipulates that the freedom of form of Article 11, 29, and Part 2 of the CISG do not apply in case of an Article 96 CISG declaration, the CISG does not want to impose a writing requirement, and therefore an autonomous interpretation, which is also supported by Article 7, to which claimant referred, does not support the Supreme Court decisions of the Mediterranean Supreme Court here, and therefore the CISG does still lead us to this freedom of form. Also, I would like the tribunal to consider that in case we would take the reservation into account and say that such a reservation does impose a writing requirement, there would be a problem in case we would have, and we're still at the procedural issues, so still talking about things that have to be implied in other cases too. What would we do in case we would have two parties that have a form requirement, but different form requirements under Article 96 of the CISG? This would lead us to severe problems. If the tribunal would now like me to still address the issue of the witness statement.
We'd like to hear from Mr. Stavridis by way of Sir Rebuttal first,
excuse
please.
me.
Mr. Stavridis,
Thank you.
Conscious of the time allocations, could you be brief, please?
Thank you, Mr. Arbitrator. The opposing counsel referred to Article 4 and she referred to the last sentence of that article, saying that, in particular, except as otherwise expressly provided in this convention, it is not concerned with, and of course, the validity of the contract, and B, the effect of the contract. But that can't be used to derogate from the argument here, because we know at Article 12 it is expressly provided that, of course, the parties cannot derogate from the effect of an Article 96 reservation. And, of course, at Article 96, we see, if the tribunal gives me just a second to find Article 96. We see that it is the law of the place of business that has made the reservation which applies at the end of that provision. So that matter itself is expressly provided for, and Article 4 cannot be used as a reference to rebut that point. Thank you.
Thank you, Councillor. Ms. Keala, if you will accept, we'll come back to witness statement after we've heard on the merits issues. Again, checking my clock, you have some time left, and we will hear you if time, overall time permits. We'll hear you briefly, but later. With that then, that concludes this part of the hearing on the Article 96 choice of law issues, and I'm now going to invite Mr. Hall to address us on the merits issues, and as I said at the outset, we are significantly more interested in breach of contract avoidance damages issues than in the question of whether or not the contract was actually amended. So you're welcome to address that latter issue, but so for us it's on a lower priority. So, Councillor, please proceed.
Thank you, Tribunal. And I'll take the Tribunal straight to the issue of nonconformity. Respondents' use of child labour in its business was a grave breach of the ethical standards that it pledged to uphold and amounts to a failure to deliver goods that conformed to the particular purpose of resale in Domasiran stores throughout Oceania. And I can have 3 steps that I'd like to take the Tribunal through to prove this point. First, that the particular purpose of these goods was their ability to be resold in Domasiran stores in compliance with their high ethical standards. Second, that respondents' use of child labour meant that these goods could not conform to that standard. And third, that that breach was a fundamental breach, allowing avoidance of the contract. On my first step, Article 35 2B of the CISG requires the goods to be fit for any particular purpose expressly or impliedly made known to the seller at the conclusion of the contract. And Clause 1 of the contract, in regards to the goods, states that these goods must hold the Yes Casual brand. And once that brand is attached to those shirts, respondent knew that those shirts in no way could be associated with unethical practices. And I can refer the Tribunal to 3 parts of the materials here. The first is on page 6, and this is at number 6. And it says that claimant is known, so Oceania Plus is known for its high ethical standards, which feature prominently on its website and its public relations. The second is on page 7 of the materials. This is at 11. And this paragraph has been agreed to in its entirety by respondent in their statement of defence. And it speaks of the delivery date and also knowledge here that that would be the latest date that would allow for transport to Domasiran's warehouse and then to the retail stores throughout Oceania. And the third point is at page 53 of the materials, at 16, in the last sentence. And that is that the brand of Yes Casual is well known to manufacturers of clothing within Equatoriana, where respondent has its place of business. So we can see from these 3 points that respondent knew that Yes Casual is associated with a very high ethical standard, and that once that Yes Casual logo attached to those shirts, that respondent had to ensure compliance with those high ethical standards to be able to resell these particular goods in Domasiran stores throughout Oceania.
Councillor, I'm struggling a bit there because it may be I buy a Yes Casual polo shirt because they're comfortable, they fit, I like the colours, but because I know the brand, why does it follow that I know all the background and all this high ethics, all of that? Would all ordinary consumers be so interested to know all of that?
Certainly, ordinary consumers would be, and they buy this brand simply because of those high ethical standards. The Oceania Plus and Domasiran, they ensure within all of their advertising and in regard to all of their advertising that there is a high ethical standard. It is something which is intrinsic within this particular brand. And so when the public go to purchase that shirts, they know that. And you can see that too from the materials, that The moment the association with child labour became known to the public, sales stopped almost immediately. And that shows how important this connection with high ethical standards is for consumers.
Before you go on, are you imposing an obligation on the seller to conduct the kind of research that would lead them, for example, to look at the website, as opposed to requiring the seller to tell, to requiring the buyer to tell the seller what it is they require in terms of conformity with a particular quality of goods? Isn't that imposing too much of an obligation on the seller to do research to figure out what the buyer is looking for?
There is no obligation here that we are trying to impose upon respondents. And that's firstly because this particular brand is well known to manufacturers in Equatoriana, where Respondent is situated, so they already know of these high ethical principles. The second is that in 2008, preceding this contract, there was an audit as well, where Respondent had extensive discussions in regard to what the high ethical standards were. So there is no need for research being imposed here. Respondent simply knew. And this
Counsel, I have a question. Of course, a lot of companies put on the website higher ethics standards, but you cannot just impose such obligation to a supplier. What kind of work or undertaking or investigation or auditing have you done? If you didn't do this, whether you should have a kind of shared liabilities for failing to meet such kind of standard?
Certainly. Article 9 of the CISG binds parties to any usage to which they've agreed and any practices which they've established between themselves. And there was a practice established in the 2008 audit between the parties that no child labour would be used. And this is in regard to your question here. I can refer to 3 points. Page 52, Procedural Order 2.4, as I've mentioned, this policy was extensively discussed between the parties. And in regard to those particular discussions at page 35, Respondent agreed that one of the issues was in regard to child labour. And then as a result of that, Respondent complied by removing a manager that had engaged a supplier that had used child labour. And that's even further in the business than in this particular instance here. So in regard to previous practice, we can see that the audit was conducted, Respondent knew about the high ethical standards, they were extensively discussed, and so there's no imposing of any particular obligation here. And there's no need to share risk in this regard, because it was known by Respondent of those high ethical standards.